Hello, and welcome to Intangify. I'm your host, Matthew Asbell. Intangify is a podcast where we talk about the intangible aspects of business, largely focused on entrepreneurs and startups who have all sorts of interesting issues and concerns as they work towards building their businesses. And the intangible aspects include, things like what I do, which is intellectual property law, in which case we seek to protect what people create. But also many other aspects of business, such as communication, or social consciousness, or other things of that nature that really are important to forming a business and building a business. My guest today is Laura Winston. Laura Winston is my partner at Offutt Kerman, where we both practice intellectual property law, and in fact, she leads the intellectual property practice group in my firm. But Laura has some other parts of her life as well. So welcome, Laura. Can you come off mute and say hello to our guests real quick?
Hi, Matthew. It's great to be here. Thank you so much for having me today.
Glad to have you. It's as if I don't see you all the time, but here we are. But Laura, apart from your work, and I want to ask you a little bit about your work as the practice group leader and as an intellectual property attorney, but I know you do some other things, some in the realm of education and some in the realm of art. And maybe could you share a little bit about who you are and what you do with our audience?
Yeah, it'd be my pleasure. Thank you. So you mentioned education first, so I'll address that first. I'll clue you in on the fact that you and I do something together, which is co-teach a trademark law class at Fordham Law School. And really, I have you to thank for bringing me into that role as an adjunct professor. It's not something I was necessarily seeking out. And there was a need for some assistance. And you asked if it was something I'd be interested in. And after thinking about it a little bit, didn't take me long to say, yes, that does sound like something I would like to do. And we completed our first semester in the fall of 2022, and very much looking forward to doing it again this fall.
Yeah, that aspect also was something you were naturally good at, right? I mean, I think it's, in our field, we talk to small businesses and entrepreneurs and all different types of clients all the time about their legal issues. And it's really sort of a similar thing to talk to students who are learning about the law and help them understand in the same way we need our clients to understand what it is we do and why they need to worry about it.
Yes, and I remember you pointing that out to me when I said, well, I'd never been a teacher before. You kind of pointed out to me that yes, I have been. And at the risk of blowing my own horn, I have been told that I am good at explaining things. And I think it's one of the reasons why I've had a career that's lasted as long as it has in this field, working with startups and entrepreneurs. And yes, I think it was the right fit at a good time.
So then before you tell us a little bit about your artistic endeavors, maybe you could tell us a little bit about your legal endeavors. How'd you get into this field? What's it like being the leader of a group of intellectual property attorneys? And how has all that worked for you?
Well, I'll try not to lay out the whole roadmap of my career because I think that would exceed the time that we have on this podcast. But when I went to law school, I was fresh out of undergrad, and I had been a child development major in undergrad with a goal of getting involved either in family law or child advocacy when I graduated from law school. Went to a law firm that didn't have those practice areas, at least not initially while I was there. And I went in as a general litigation associate, and the firm had some patent and trademark lawyers, and one of the patent lawyers came to me one day, and as the most junior person in the office, he was looking for somebody to assist him with his work. and said, how'd you like to work on a trademark application? And, my first question is, well, what is that? And once it was told to me and explained to me, I worked on it. He was a great mentor, still remember him fondly, and discovered that I really liked this practice area, took on more and more work in that area, and ended up leading to me building a career about it. And coming back to the family law for one moment, we did have a partner join our firm back then who did family law. And when I expressed an interest, I worked on a couple of assignments and realized that I liked IP a lot better than family law. So the accidental path that my career took, I think was the right one for me.
I always love the stories, and particularly of people I know in our field who I've met and had these other parts of their lives that somehow wove into what they do now. Mm-hmm. And speaking of that, I wanted to remind you to tell us a little bit about your artistic endeavors and then maybe how they weave into what you do now.
So historically, I have not been an artist, but I was always fascinated with glass art. And in 2016, I took a weekend class at a public access glassblowing studio called Urban Glass. It's located in Brooklyn. Shout out to them. It's a wonderful place. And basically got me hooked. And since then, I've been trying to learn as much as I can about the craft. I've taken anywhere from 1 and 2 day workshops to a few intensive 6-day courses at the Corning Museum of Glass up in Corning, New York, where we're basically in the studio all day long, except for some lunch and dinner breaks and maybe a little evening time off. And just, trying to improve, get better. And it's been a hobby for me. But I do have aspirations of learning more, becoming more competent, and maybe eventually, trying to sell some work. I haven't done that yet, but it is a goal of mine. And just to show what I've managed to accomplish, I'm just showing a couple of vases that I made, which is an example of the types of things that I like to do.
They're beautiful. They're just missing some flowers.
Thank you. Yeah, I started that too late. I have had flowers in them at times. I've got pictures of that.
So how do you tie in this love for glass blowing and glass art with what you do every day?
So there are two things I like to talk about: trademarks and glass. And I thought, it might be nice to try to combine these at some point. And there's a professional association called the Glass Art Society that has annual conferences, and they were looking for discussion proposals, topic proposals for their conference, which took place a couple of weeks ago in Detroit. And I pitched the idea of an IP presentation geared towards people who are working in the glass field, whether it's artists, gallery owners, studio owners, suppliers of materials and tools. And the Glass Art Society took my idea and expanded it into a full-fledged panel that they titled Legal Toolkit for Glass Artists. And we presented on there were 3 of us. One of them is another glass-blowing lawyer like I am. And we presented on a variety of legal topics of interest to glass blowers, not just IP, but contract basics and employment law issues. And our panel was really well attended with about 40 attendees. And even not only were we introduced by the winner of season 3 of the Netflix show Blown Away, which is a glass blowing competition show. So I was a little starstruck from that, but it was also attended by people who were contestants on that show who wanted to see what we had to hear. So that was a lot of fun.
So I don't know if you noticed as you were explaining all that, but I disappeared. I got kicked out of my own podcasts. So I only caught the last line or two, but
you'll have to go back and listen. It was an explanation of my time in Detroit and how that came about.
I'll have to go back on that. I'm glad I was able to get back in. I got one of those, computer automatically trying to restart right now things.
Oh no. Okay.
Craziness.
Could have been worse.
So I did want to ask you sort of a glass blowing, sort of a trademark question that I didn't prepare you for, but I'm sure you're going to be able to handle.
Thanks.
Because you said you went to this school in Corning, New York, and I have a recollection, just as a layperson, of something called Corningware. Is that related? Is that a trademark? Is there a Corning School of Glass? The people who do Corningware?
Exactly. Corning, it's a city in upstate New York. It's on the southern tier, and they are the company Corning. It's had different names over the years. I know at one time it was Corning Glassworks. They were the company that developed Pyrex brand heat resistant glass, and they also have made ceramic products over the years. And also Steuben is located in Corning, New York, which is an old time crystalware company. So Corning has a big glass history, and the Corning glass company is still located there. And the museum and the studio are both affiliated with the company. So yeah, that is, and it is, it's a old and successful trademark. Corning and Pyrex, of course, subsists to this day as well.
Speaking of tying your artistic passion with your profession, just happened to be.
Yeah.
Well, great. We're going to go to a break. When we come back, I want to talk a little bit about actual issues of intellectual property law that would impact the entrepreneurs and startups in today's day and age. So you've been listening to Intangify on talkradio.nyc, and we'll be right back.
Are you a business owner? Do you want to be a business owner? Do you work with business owners? Hi, I'm Stephen Fry, your small and medium-sized business or SMB guy, and I'm the host of the new show, Always Friday. While I love to have fun on my show, we take those Friday feelings of freedom and clarity to discuss popular topics on the minds of SMBs today. Please join me and my various special guests on Friday at 11 a.m. on talkradio.nyc.
Are you a conscious co-creator? Are you on a quest to raise your vibration and your consciousness? I'm Sam Leibowitz, your conscious consultant. And on my show, The Conscious Consultant Hour, Awakening Humanity, we will touch upon all these topics and more. Listen live at our new time on Thursdays at 12 noon Eastern Time. That's The Conscious Consultant Hour, Awakening Humanity, Thursdays, 12 noon on talkradio.nyc.
What really drives success in business? Introducing Intangify, the show that explores the intangible assets that create value and growth. I'm Matthew Asbell, your host and an attorney focused on innovation. Join me Fridays at noon Eastern to discover how innovation, culture, and other intangibles shape driving companies from startups to established businesses. We'll share strategies to unleash your business's true potential. Tune in live on talkradio.nyc, Fridays at noon Eastern, and Intangify your business today.
You're listening to Talk Radio NYC. Uplift, educate, empower.
Welcome back to Intangify. I'm your host, Matthew Asbell. My guest is Laura Winston, practice group leader in the intellectual property group at Offutt Kerman, but also a professor and a glassblower. Before the break, Laura, we were talking a little bit about how these seemingly very different fields have intersections, and and sort of the joy sometimes in finding those,
Mhm.
whether it's because you go and take a class in the home of a famous or a well-known trademark having to do with glass, or it's you go all the way to Detroit and give a presentation on the legal aspects tied to the glass industry. Um, one thing I wanted to ask you further about that before we get into some more trademark-oriented stuff is, as you kind of started getting into the art of glass blowing in 2016, you've been sort of taking steps along the way to kind of learn and become a part of that network, that industry, that culture. And I wanted to see maybe if you could tie in a little bit about that, the education, the business, the networking, and the legal aspects that sort of have been there, steps you've taken as an entrepreneur or startup would do when they were entering a new industry, not accusing you of quitting your job and going to become a professional glass blower, but as someone who sort of delved into that, I suspect you've had some exposure to those sorts of things.
There are days when I wouldn't mind, but for the most part, I'm happy with the way things are right now. So it's funny, when I started, I was really just sort of interested in exploration, and I didn't really think about long-term and didn't think about the fact that there would be a community around this. But, after taking these classes, I've met a lot of people. I've had the opportunity, besides what the Starstruck features I mentioned before about meeting people from the Netflix show, I've had the opportunity to take classes with like well-known and talented glass blowers. And I've also found that Instagram has been an incredible way to learn as much as I can about the field. I follow many, many different glass blowers and studios. Some of them have followed me back, which is nice, and we interact. And just learning as much as I can about how people are doing this, the types of facilities they're working in. I've discovered that glass blowers tend to be tinkerers and do-it-yourselfers, just like many patent attorneys tend to be. And they'll do things like build their own studios, including building their own furnaces and other such things. That is something I don't picture myself ever doing, but it's just been part of the whole, learning as much as I can about the hows and the whys of how people are doing this. And I learn something new all the time. It's pretty amazing.
I think you put it really well when you say that there's a community that you discovered and all these different aspects of the community, which were not the reason you got into it, but become sort of the lifeblood of that passion. For myself, in different industries, I'm definitely not even a budding glass blower, but I've always been into technologies, and I've always been into food and beverage and wine and things of that nature. And finding communities around those have also been similarly fulfilling. I think with regards to like technology or really any kind of startup or entrepreneur looking to get into new areas or different areas than they've had in the past, it's helpful for them to really understand how what we do changes over time in the big picture, because you hear about, hey, so and so could do this, and you rely on that happened 10 years ago, but there's sort of an ebb and flow of the way the law works in relation to protecting these businesses. And I thought we could have a little conversation about that aspect, if you don't mind.
Sure, of course.
So I think when we were talking in advance of preparing for today, we had a little discussion about this sort of ebb and flow, that kind of the law goes in phases where things become easier to protect and to enforce, and clients want to do that, and then some years later, kind of generally speaking, the same thing that you could have done would have been harder. Can you think of an example, perhaps in maybe the recent cases that we've been reading about that might impact people in different industries listening to us today?
Yeah, I mean, I think a great example of that is the recent Supreme Court decision that pitted parity and First Amendment rights against the ability of a well-known brand to protect itself from money-making parody ventures. And some listeners may have heard about this case because it's one that's been in the mainstream news. Jack Daniels, which we all know, and which is a brand that's beloved and often emulated. They took issue with a dog toy company called VIP Products that makes dog squeaky chew toys that are themed after famous liquor brands. And one of them was called Bad Spaniels. It was really looked a lot. It was a rubber squeaky chew toy that looked a lot like a Jack Daniels bottle. And the label was very reminiscent of the Jack Daniels bottle. And it used besides being called Bad Spaniels, it used wording on the bottle that parodied Jack Daniels, but was really talking about defecation and scatological functions that dogs and others do. So Jack Daniels didn't like this. They sued the company. The company argued that they had the right to do this because it's a parody protected under the First Amendment. It went through the court system all the way up to the Supreme Court. And the interesting thing about trademark cases that make it to the Supreme Court is they rarely break down along what we think of as typical political ideological lines. So this case was actually a unanimous decision that found that Jack Daniels trademark was being infringed, and the fact that it was parody didn't matter when this company was so clearly claiming to have trademark rights in Bad Spaniels and was making money off of them. And so Jack Daniels was victorious. And when you mention the ebb and flow of the way these things tend to go, there was a case, didn't make it up to the Supreme Court. It was maybe about 8 or 10 years ago, where Louis Vuitton, famous luxury brand that does not laugh off any attempts to make fun of them, they sued a company called Chewy Vuitton. The brand was Chewy Vuitton, making dog toys, and they lost. It didn't make it up to the Supreme Court, as I said, but they lost at the lower court levels. And I believe that if that case were brought today, Louis Vuitton would be more likely to win. So we do have a back and forth. It's always been a conflict between First Amendment and trademark law. And right now the pendulum seems to have swung more towards the trademark side.
Yeah, it's interesting to see how it's changed. I mean, when we're growing up in our profession, we kind of go through some of the earlier cases. We tend to rely on that was our understanding, and then it kind of gets changed as a result of how the law has changed or the interpretation of the court. I struggle with this idea, though, that an alcoholic beverage company would have a problem with a dog toy, and a dog toy that's not pretending to be the alcoholic beverage company, but rather, sort of saying, yeah, you make alcoholic beverages, we're going to make chew toys that look like alcoholic beverages because it's funny. Why is that infringing?
I mean, one of the arguments would be that Jack Daniels also makes other products because it is such a beloved and storied brand, they do sell a lot of ancillary products. Now, the court even said, Elena Kagan wrote the opinion, Justice Kagan, she even said that that Bad Spaniels is not likely to, that Jack Daniels would not be likely to make a Bad Spaniel style toy that makes fun of their own brand. But, dog toys would be in their realm. One thing I want to clarify that I said earlier is that the case is still being considered for whether this does actually cause likelihood of confusion between the two brands. The defendant, the Bad Spaniels people, had argued that the case shouldn't even be brought against them because it's so clearly a parody. And what the court said is no, it can be brought. But since the standard for trademark infringement is likelihood of confusion, it's now going to be back down to the lower courts to consider whether there is. And one of the things Justice Kagan pointed out was that the fact that it's parody may actually reduce the likelihood of confusion, but it still comes down to whether there is confusion or not. I thought that was an interesting, she almost, even though she was finding in favor of Jack Daniels, she almost seemed to be taking a little favor position towards the Bad Spaniels people in that case.
Yeah, it's sometimes lost on non-lawyers and even lawyers that what's going on procedurally really can have a lot of impact on what's really being said and what it really means, because it's very easy to sort of latch on to, oh, okay, now dog toys are infringing, to no, dog toys could be infringing. It's up to it's up to a court to decide. We're just not going to throw it out.
Exactly.
So that's a real important aspect. It came up in another case recently that's also had a lot of press because it sort of revolved around these non-fungible tokens, the NFTs, and this was the Meta Birkins case that we had in New York, where the sort of well-known Birkin bag was created in a digital form as a Meta Birkin with the name Meta Birkins. And there's a lot of stuff in the media about, hey, does that mean that, well, first of all, is this artistically relevant? Are we going to allow this sort of thing? But also, is that infringement? And a lot of stuff in the media is for looking at the commercial aspect. Well, okay, he created this thing for the purpose of making the money from the artistic endeavor. And big change from past precedent and past law in terms of how we interpret it, though.
Right, because we're talking about literally non-tangible goods versus the luxury bag itself, the big luxury bag. Some people, not many, may own, and in that case didn't involve parody, so that element was removed from there. It was really just, we're going to have an NFT designed after this bag.
But it was referring to the brand, even if it wasn't a parody, it was intentionally to refer to the brand. Yeah. So great. Well, we're going to go to a break. I'd love to come back and talk a little bit more about that case and some other issues when we come back. You've been listening to Intangify on talkradio.nyc, and we'll be right back.
What really drives success in business? Introducing Intangify, the show that explores the intangible assets that create value and growth. I'm Matthew Asbell, your host and an attorney focused on innovation. Join me Fridays at noon Eastern to discover how innovation, culture, and other intangibles shape driving companies from startups to established businesses. We'll share strategies to unleash your business's true potential. Tune in live on talkradio.nyc Fridays at noon Eastern and Intangify your business today.
Hey everybody, it's Tommy D, the Nonprofit Sector Connector, coming at you from my attic. Each week here on talkradio.nyc, I host a program, Philanthropy in Focus. Nonprofits impact us each and every day, and it's my focus to help them amplify their message and tell their story. Listen each week at 10 a.m. Eastern Standard Time until 11 a.m. Eastern Standard Time, right here on talkradio.nyc.
Are you a conscious co-creator? Are you on a quest to raise your vibration and your consciousness? I'm Sam Leibowitz, your conscious consultant. And on my show, The Conscious Consultant Hour, Awakening Humanity, we will touch upon all these topics and more. Listen live at our new time on Thursdays at 12 noon Eastern Time. That's The Conscious Consultant Hour, Awakening Humanity, Thursdays, 12 noon on talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc. Now broadcasting 24 hours a day.
Welcome back to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Laura Winston, my partner at Offutt Kerman, practice group leader in the intellectual property law group there, a professor, and a glassblower. And, you know, when lawyers talk to lawyers, as we're doing here, we tend to geek out a little bit about cases and what's going on. But you know, we need to bring it back home for the businesses, for the startups that we regularly work with. So as much as I'm tempted to keep talking about what happened in a couple recent cases that really is quite fascinating to us, we're gonna try to think about this from a more practical bent. So Laura, with regards to these types of cases, these sort of changes in the ebb and flow of the law that we were talking about, how does that inform you and inform your clients, or how do you inform your clients really to give them, the right advice as to whether they should do something or not do something, how they should protect themselves?
Thank you for asking. And one thing that I find pretty exciting about our practice is that when we're working with startups and entrepreneurs, as we both do, we tend to be at the forefront of what can sometimes be new issues, new technologies, new business ideas. I went to an event just last night. I have a client called PingPod. Their business model is opening ping pong parlors, and they've got several locations in the New York City area already, and they've expanded to other geographic locations as well. And what differentiates them from other such places is they are completely autonomous. You register through an app. You get an access key through the app, and you can basically sign up and go play ping pong. I keep saying the company's name, ping pong, table tennis, 24/7, anytime you want. They keep their overhead low by not having staffing, and they have excellent facilities. I actually hit a few balls last night with one of their coaches, who I think took it easy on me, but I think I've got a pretty good serve, and I didn't do too badly, and I'm actually looking forward to going back and playing. So the idea that this is like a new business that hasn't been done before, I think really is not only exciting as a trademark lawyer, but presents a lot of opportunities. And my goal when I work with startups or entrepreneurs is to really just provide education, and this comes back to what we were talking about before, on what they need to know to protect themselves and position themselves for growth, brand development, protection of the rights. And it's actually one of my favorite parts about the practice is being able to work with a company in those early stages and see the growth as it's happening.
Yeah, and it's kind of our job to sort of think about what their new thing that they're doing is, how to properly protect it and give them advice, which hopefully they follow. But then we also have to put that into the context of the changing law. And so then we have to look at, well, gee, what's out there that existed before? What does it say? Is this somehow going to be violating anybody's rights, and how would we get around it under the way the law has changed? I don't think in the context of your client and what you're doing with Ping Pod, there's that particular issue as far as I can tell, but that's what we have to do, right? We have to go, okay, this is what you want to do. Here's how you can protect it, but also here's what might be a problem under the law, under the prior rights. How do we get around these potential problems that we've found? And how much do we want to invest in getting around those problems? Is that fair?
Yeah, that is very fair, because sometimes a client may have a trademark that they're interested in, but if it looks like someone else is already using the same mark, they may be able to take some steps to try to avoid any risks with them. But it's a question of whether they want to invest money into trying to get that done, or just choose a completely different name, and sometimes that can involve some additional costs. So there's always a lot of balancing that needs to be done. And I think it's one of the reasons why working with startups can really present that opportunity to make sure that the startups are following the right course early on.
I also was thinking as you were speaking that some of these ones that get into these big cases, like the Bad Spaniels case or the Meta Birkins case we were talking about, they kind of, historically they try to fly in the face of the law and rely on the case law as it was. And I think it's not always the case, but kind of courts and others see through that. They're sort of trying to I can't think of the word. They're trying to monopolize the exploit, try to exploit what the case law said before. So if you look at Bad Spaniels and you were relying on Chewy Vuitton, you're thinking, oh, well, come on, it's the same kind of thing. Chewy Vuitton could do it. Louis Vuitton, who goes after everybody, wasn't really able to stop that. So these guys, Jack Daniels, shouldn't be able to complain about our Bad Spaniels. I think similarly with Meta Birkins, there was this Rogers v. Grimaldi about Ginger Rogers and Fred Astaire case. That basically says, if it's got this minimal amount of artistic relevance, then we're gonna look at it from a fair use perspective, look at the freedom of expression and consider that much more greatly before we say that you're infringing. And then here comes this okay, well, fine, so we're gonna do this minimal amount of artistic expression, make an NFT, call it Meta Birkin, and sell it. We should be able to do that because that's what the case law pretty much said. And then then you see the result going the opposite direction, right? Actually, we didn't exactly mean it the way you seem to have interpreted it.
Exactly, and it doesn't necessarily mean that the old case is no longer good law. It just means that it's being interpreted in a way where your facts don't fit the holding of the prior case. In fact, Justice Kagan made that pretty clear, that they weren't overruling the Rogers v. Grimaldi case. They were just not even carving out, like distinguishing the Bad Spaniels situation from that older case.
Yeah, they make it fun
the
for us.
surprise of Bad Spaniels, I think they really believed in their position.
I think honestly, I would have believed in their position too. In fact, I did believe in their position, and hey, we can be wrong, or that's how things go. So when you're advising clients, startups, entrepreneurs, small businesses that are growing and trying to protect themselves, and you're considering how the law changes and can be reinterpreted, I think we've talked a little bit about aspects of new technologies coming into play, but I'd say there are other things that are sort of happening in our time, trending issues, and things like sustainability and environmentalism as an example, or cannabis, hot topic, a lot of people talking about. When you start to see more and more of this kind of stuff coming out as the law is changing and evolving in relation to these, how you're advising clients, in the virtual Wild West that we don't know what the law will be. How do you deal with that?
Yeah, it can be really challenging. It's interesting that on the one hand, sustainability, which is so important, is really at the forefront of what so many companies and organizations are thinking about. And the U.S. Patent and Trademark Office, which is the body that registers trademarks, as well as examining and granting patents, is taking this very seriously and is giving some special perks to innovators in that area. Expedited examination of trademark applications, for one thing. They've even started an incentive awards program for people who are coming up with sustainability-related businesses and brands. But then we have to worry about something like greenwashing, where a company is going to call something green, and it was actually some time, or other ways that they're either intentionally misleading in what their product can do, or maybe holding out greater hopes and it's more aspirational than what it really is. And it was some time ago that the USPTO, Patent and Trademark Office, actually put out a special guide for when something could have green in its trademark, and unless it was actually referring to the color green, or did not clearly make it sound like it was a sustainable product, there would be some inquiry as to whether the product actually had sustainability features. At the same time, and this is not directly a trademark issue, but there's been some backlash on companies' motivations and efforts to be involved in sustainability. And there have been a number of shareholder suits and even some regulations passed against companies that are touting ESG. The idea being that a publicly held company's goal is to make as much money for the shareholders as they can, and not put these efforts into ESG. And I think that's kind of a tricky area to navigate too, which does not have direct impact on what we're doing right now, but everything in the business world is going to affect the trademark world in some way or other.
Yeah, so two kind of points, if I can remember them, while you that sort of alluded to without stating, this idea of the Patent and Trademark Office regulating what can be registered and protected under trademark law is different from this aspect of what people can say they're doing and the truth of that, right? That deceptiveness aspect. There's interaction between them, but I think there's among many business owners out there, at least small business and entrepreneurs out there, a misperception that they need to register a mark that has green in it, and what that means is they're trying to claim ownership of that term for themselves in relation to whatever goods or services they're offering, not necessarily that they can't use that. The issue of the use falls outside of the realm of the United States Patent and Trademark Office and closer in the Federal Trade Commission, right, and related agencies that would address those sorts of things. So it gets even confusing because people come to us as a specialist on IP, but there can be issues that are not IP related in terms of what they're trying to do. I also briefly wanted to say, and then I'm going to go to a break. I'll give you an opportunity to respond after the break. But I briefly also wanted to say that it's also about governments trying to set up incentive structures. And sometimes we set up these incentive structures thinking that it's going to encourage the type of behavior that the government we would like to have. We would like more sustainable businesses. But sometimes these incentive structures backfire in the sense that it encourages people to see how they can get the benefit of the incentive without necessarily putting in the investment to do the good that was desired of it. So you've been listening to Intangify on talkradio.nyc. When we come back, Laura, I'll ask you a little bit more about the incentive structure and the trademark office role. But you've been listening to Intangify on talkradio.nyc, and we will be right back.
Are you passionate about the conversation around racism? Hi, I'm Reverend Dr. TLC, host of the Dismantle Racism Show, which airs every Thursday at 11 a.m. Eastern on talkradio.nyc. Join me and my amazing guests as we discuss ways to uncover, dismantle, and eradicate racism. That's Thursdays at 11 o'clock a.m. on talkradio.nyc.
In a post-COVID world, you may have many unanswered questions regarding your health. Are you looking to live a healthier lifestyle? Do you have a desire to learn more about mental health and enhance your quality of life? Or do you just want to participate in self-understanding and awareness? I'm Frank R. Harrison, host of Frank About Health, and each Thursday, I will tackle these questions and work to enlighten you. Tune in every Thursday at 5 p.m. on talkradio.nyc, and I will be frank about health to advocate for all of us.
Hey everybody, it's Tommy D, the nonprofit sector connector, coming at you from my attic. Each week here on talkradio.nyc, I host a program, Philanthropy in Focus. Nonprofits impact us each and every day, and it's my focus to help them amplify their message and tell their story. Listen each week at 10 a.m. Eastern Standard Time until 11 a.m. Eastern Standard Time, right here on talkradio.nyc.
You're listening to Talk Radio NYC at www.talkradio.nyc, now broadcasting 24 hours a day.
Welcome back to Intangify on talkradio.nyc. I'm your host, Matthew Asbell. My guest is Laura Winston, the practice group leader at Offord Kerman Intellectual Property Practice Group, professor and a glassblower. And Laura and I were talking a little bit before the break about the legal system, in a sense, how it impacts our advice for our clients, how we work with businesses, small businesses, startups, entrepreneurs, and how it impacts the advice we give them. And before the break, we were talking a little bit about incentives and maybe opportunism, and maybe that's the right word to use, because the trademark office sets up an ability to expedite your applications, or an ability to earn a reward, trying to encourage certain businesses and behaviors to make it easier for them. And similarly, as we talked about earlier, the courts, establish the law and say, look, we're going to recognize this is okay. This type of use, for the example of bad spaniels we were talking earlier, this type of use should be acceptable under this Chui Vuitton and prior case law, because you're parodying and people won't be confused. But then it changes it on you, right? The issue often when you see these changes happen is often when people try to be opportunistic based on what that law is. They look at what the trademark office's incentive program is. They look at what the last case said about the particular issue, and then they try to rely on that, be opportunistic. So Laura, I'm wondering if that has been your experience, or what has been your experience with sort of clients trying to ride the wave of opportunity that seems to be clear based on the case law or what the trademark office has regulated.
Yeah, so I mean, I know that I definitely see clients riding the wave of what the current trend is, which is why I've, had a number of clients who are in the NFT space, which, most people didn't know what, maybe a couple of these tech people did, but a lot of people didn't know what NFTs were just a few years ago. But I've had, several clients who came to me looking for trademark related help for their NFT businesses or their NFT authentication type of businesses. So I've definitely seen wave riding in that way. I'm fortunate to say that I have not seen anybody come to me with something like a sustainability product, just in that sort of greenwashing sense where, sure, they can claim it's sustainable, but is it really? So at least not that I'm aware of. So I haven't been down that road. I think it's a shame if people do that just to get expedited by the USPTO or just to get some kind of award. And I mean, because the goal is to serve the greater good. The USPTO was doing something similar during the pandemic, where they were expediting applications that were related to products and services that would address the issues that we were facing during the pandemic. And I like to think that didn't cause anybody to do anything that was untoward or inaccurate. But maybe I'm just too much of an optimist. I don't know.
I mean, I don't know if it's so much about being opportunistic, optimistic, pessimistic. The government and the courts set the rules of the game, and we try to play the game by the rules to accomplish our clients' goals. It doesn't necessarily mean, I mean, it's hard to hold that high horse of the greater good when you're talking about, what a business is trying to accomplish. It may be the mission of the business. It may be that may be part of what they're doing, but not necessarily for the IP that we're trying to protect. But I think that's fair. I mean, I think one would hope that people would do things for the right reasons. Often the right reasons are the selfish reasons. And, I just won't be able to go on record and say that I've helped anybody do something like that. And hopefully I haven't. But usually and I have lots of environmental sustainability type of clients. Usually it's, they are really contributing in a great way to advancing society, and you feel like you're a part of something good when you're serving them.
Exactly.
Not a case.
And even if it is a business, a for-profit business designed to make money, the mission is still a good mission. So.
For sure. Now we only have just a few minutes left before we have to end, and so I wanted to kind of circle back, Laura, and ask you, what's the take-home message you would want the entrepreneurs, startups, here listening to you today or listening to a future version of this recorded version of this podcast? What's the message you'd like to leave with them?
So I know this podcast is dedicated to IP and its importance. A startup and an entrepreneur has a lot of things to do, a lot of roads to navigate. IP should be something where it's a great idea to educate yourself as much as possible. But when it comes to making your decisions on how to protect yourself, there's a lot of DIY options out there. And the U.S. Patent and Trademark Office has a portal that makes it look deceptively simple. But really, I know I've seen a lot of things go wrong. I know you have, with people trying to, say, register their own trademarks. And it really is best to consult with a professional who works in this space and does it day in and day out, to avoid. Sometimes problems can be fixed, and you and I have both seen a number of those. Other times, you have to just throw away the money you've already spent and start over. So getting it right the first time is key.
Sometimes it's very much not about what the dollar figure of the work to be done is, but more about the relationship with the person who's going to be doing that work. And there are technologies and people out there who are lowering the barriers to entry to make it easier for people to go in and do things themselves, but in doing so make those mistakes, which end up being more costly. Versus having someone you trust who can work with you and who can understand your financial limitations, your concerns, and work with you through a strategy and plan that fits your budget and your needs over time. And
guide you accordingly. Yeah, exactly.
Yeah. Great. Well, Laura, I really appreciate your joining us today. I will be seeing you in just a few days. But I thought maybe you could share with the audience some news about what you and I will be doing in just a few days to come next week.
So on Thursday, June 29th at noon Eastern Daylight Time, Matthew and I will be hosting a webinar entitled "The Global State of Trademarks Today." We're going to touch on some of the issues we touched on today and some other ones as well. We're going to talk about the gathering of trademark professionals in Singapore that I attended last month, and from there build on what are the hot and trending topics in the area of trademarks. And feel free to contact Matthew or me for information about that or how you can register.
Thanks so much. I very much look forward to the webinar. And for those of you tuning in, I hope you'll tune in again next week and every Friday at noon Eastern Time for our next episode of Intangify. You're listening to Intangify on talkradio.nyc. Have a great weekend.
Thank you.
You're listening